Hello, everyone, and welcome to Your Rights in COVID-19, an ATPE Member Legal Services webinar. My name is Kate Johans, and it's my honor to serve as the Marketing and Communications Director for ATPE. Joining me today is ATPE Member Legal Services Managing Attorney, Paul Tapp. Paul has been with ATPE for 23 years. He has been serving Texas educators for his entire legal career. He is a proud graduate of Texas Public Schools. Fun fact, he and I went to the same high school in El Paso, Texas, though we did not graduate the same year.
As you can probably tell from our hair, we are slightly different.
He is a graduate of the University of Texas at Austin, both for his undergraduate and his law degree. So before we get started with all of your questions, we have received so many very thoughtful questions from educators across the state. We do have a couple of housekeeping notes to take care of. One is that we can only answer general questions. So if you have specific personal information, please do not include that in your questions for this event. If you are an ATPE member with specific questions relative to your situation, please contact the ATPE Member Legal Services Department. Without further ado, though, let's get started. Paul, I feel like every day, and this week has been no exception with the Attorney General's guidance and some corresponding updates from TEA, it seems like every day things are changing in regard to this situation. And I have seen some people describe it as whiplash. Who's really in charge here? I mean, what entities should educators be listening to?
That is a very good question. And I will tell you that we could spend the entire hour on that subject, and I'm not sure we would actually know it a whole lot better than we do at this point. As anyone who's been paying any attention knows, there are a lot of interested parties in this case, going from the governor through TEA to local school districts, and all play a part in this. Again, not going to be able to explain exactly how it works. And honestly, this is a completely unprecedented situation. I mean, we've all heard that term, and it is honestly true. We're talking about a lot of governmental entities, governmental officials who are dealing with something that no one in their position has ever dealt with before. So there are some questions as to what the authority of individual entities are. Perfect example, Kate, like you just said, was the Attorney General opinion that came out day before yesterday. We have seen different local health authorities roll out orders saying that schools could not begin in-person instruction earlier than this particular date or that particular date. And everyone kind of understood that that was the case. Districts were making plans based on that. And then day before yesterday, the Attorney General came out in an opinion letter and said that these local health officials do not have the authority to make those kinds of orders preventatively, which is what was going on now. Basically, we don't want COVID cases to occur in schools, so we're going to keep the schools closed. The Attorney General said, no, you don't have the authority to do that. It's not a situation that any of the health authorities have dealt with before. So it is a very good question as to basically who has the authority. It starts at the governor, and we have seen already that the governor does have quite a bit of authority. We saw that last spring when, by signing an order, the governor shut all of the schools down for the last couple of months of the school year. Governor can do that. So it's important to see what it is that the governor does, but it is also very important to see what specifically the governor has said. The governor can make very broad orders, like shutting all the schools down. The governor can also make orders that apply in different situations differently. A perfect example of that is the more recent mask order, where some people have to wear masks, not everyone. Some localities, masks are required. Not every locality is masks necessarily required. So it's important to see that. TEA, of course, has a role in this as well. TEA does not have the authority to close schools, but TEA has one very important piece of authority, and that is to determine when schools are going to receive their state funding, which of course is necessary for schools for their operating budgets. And by being able to say whether a school is going to receive funding, if they are 100% remote or not. TEA, even though they don't have the authority to make that determination for the schools, can very much affect, of course, what an individual school district can do. Then, of course, you're talking about school districts themselves. We've always known school districts, number one, of course, set their own calendars, set their own schedules, and we've all dealt with the fact that school districts will close if it's necessary on some, local, because of local conditions. We've all seen snow days. COVID days are not that much different than snow days, other than the fact, of course, it's much more serious. So school districts have that authority to make those decisions, but they, of course, have to look at the authority of the governor. Number one, as the governor said, we have to do something. Again, we're dependent on this funding from TEA. So are we able to do what it is that we want to do based on what the TEA guidance is? Going back to TEA, of course, the TEA has basically established safety guidance as well. The recent the recent decision by the Attorney General again goes to the fact that, okay, probably TEA has the authority to do this, but it's not anything TEA's ever had to do before. And are we waiting for some other entity to say, wait a second, no, that's not something that's within TEA's purview? So anyone who feels like they don't know for sure what it is that's going on here probably has been paying attention, because no one really knows for sure what's going on here. Because again, this is an unprecedented situation.
And it seems like, the other thing I would say is unprecedented, certainly with my years at ATPE, is the level of frustration and also stress level of Texas educators, which is completely understandable. And the situations that we're hearing about, they're heartbreaking, because people are really feeling and that they're between a rock and a hard place. They're having
Absolutely.
to choose between their serving their students, which is their calling and what they love, but also protecting the health and safety of their family and loved ones. In a time like this, could Texas educators consider going on strike? Is that even something that's within the realm of possibility?
We know that's something we've been seeing in social media again, and that comes up in these situations where educators are feeling these kind of stresses. And again, the stress is real. We certainly understand that. It is not unreasonable at all to feel like you shouldn't be in a position of actually having to put your health at risk in order to be able to do your job. But I do have to say that the law in Texas prohibits teachers from striking, or not just teachers, but any employee of a school district from striking. It's very clear that it prohibits district employees, including teachers, from striking. Doing so, and the law does not actually use the term strike. The law uses the term organized work stoppage. So basically, it's not just standing in a picket line. It's any kind of action where you and others are not going to work in some organized way in order to make some kind of political point or some kind of point about the situation. Obviously, if you're sick or for some reason you can't go to work, that doesn't apply to that. But any kind of organized work stoppage is illegal. Because it's illegal, certainly puts your employment at risk, absolutely puts your license at risk. One of the things that we have been afraid of over the years of dealing with these situations when they come up is that what the law says is that an employee that engages in an organized work stoppage can lose any benefit that they have received because of their public employment. And we've been concerned that that could be interpreted as meaning that they could lose their TRS benefits. The law does not say that they could lose their TRS benefits, but that obviously is a benefit that they've received because of their public employment. So again, it is extremely risky, not only in the short term, but very long-term consequences to consider going out on a work stoppage like that.
Okay, that's really good to know. I think that's one of the hard things right now. Are there so many little bits of information that are coming out on social media and different groups and things like that. So
and it's difficult because a lot of this, excuse me for interrupting, a lot of this is coming from other states, where the rules are different. Not every state is the same.
Yeah. Well, one area I think that is on a lot of Texas educators' minds right now is what their districts are either haven't said yet exactly what's happening, or they're just reaching out to them now. If an educator doesn't feel comfortable returning for in-person instruction, what options are even present to them? Is it too late for them to resign?
Well, and regarding resignation, the law has always been and continues to be that for a staff member that doesn't have a contract, you of course can resign anytime you want to for any reason that you want to. If you do have a contract, of course, it gets more complicated. If you are a teacher or other certified educator, the type of contract that you have is governed by the Texas Education Code. And what the Texas Education Code says is that you can, even if you signed a contract for next year, you can resign that contract as long as you do so. Give the district notice that you're doing it at least 45 calendar days before the first instructional day of the next school year. Now, as I said, calendar days, number one, not work days, and instructional days. So it's not the day that you as a teacher would report to work. It's the first instructional day when the students come in for instruction. Now, one thing that's important to note, again, because of the situation we're dealing with here, we've got a lot of districts who are either have changed the first instructional date or are considering changing this first instructional date. So that's going to affect what the last day to resign is. But as long as the resignation is in by that time, you are free to go without any risk. After that, there is risk to you if you don't go. I'm guessing there probably will be some other questions. We'll talk about that upcoming.
Yeah, absolutely. They're coming in now. I guess, is there a leave option? It seems like something that's happening, one that just came in, we're inside our time frame to resign without penalty, but it says many of us didn't know until last week that we were going to be asked to teach in classrooms with students. Go ahead. What's that process?
I will say there are a lot of leave options, and I will go over them here. But again, there are a lot of them. This is one of the places where I'm going to say that for those of you who are trying to take notes or maybe trying to keep track of what it is I'm saying as we're going here, just as a resource, we have information on the ATPE website. So if you go to atpe.www.atpe.org, you will be able to actually see a lot of what it is that I'm talking about. So if you miss something or don't get something, don't worry, just go there. So a lot of the information regarding these leave options that I'm going to go over here will be there as well. First, real quickly, there are a couple of leave options that are unpaid. I'm going to go talk about those really quickly because, again, what we're most interested in, of course, is what leave options are paid. Family medical leave is available if you have a serious health condition or a close family member has a serious health condition. So if you actually contract COVID or a close family member does, that's an option for you, 12 weeks of leave. There are restrictions on that as to who it applies to. And again, it is unpaid, that type of leave. There's also temporary disability leave, which goes on for much longer, also unpaid, 180 days, which can apply if, again, you have an illness that means that you can't work or a disability, which, again, could be a risk factor. So there are some leave options that are available, not great because, again, both of those are unpaid. There are also paid leave options. Everyone knows, number one, state provides 5 days of personal leave to every employee in Texas. District of Innovation could theoretically have opted out of that. I've never heard of one that did. So that probably is true for everyone. Local districts also provide, most local districts provide some type of local sick leave. Usually it's 5 days. Again, it's local, so it depends on what the district provides, but it's usually additional 5 days. Now, in addition to those two types of paid leave that have always been available and would apply in cases of COVID as well, there are some specific types of leave that have been created specifically related to COVID. The first is extended family medical leave, and that provides benefits if you have child care issues. If you have a child and that child would normally be in school but is not able to be in school because the school is closed, or would be in childcare and is not able to be in childcare because the childcare is closed, there is a extended family medical leave that provides benefits, and it actually does provide paid benefits. It's different from the other family medical leave that I was talking about before. So that is one option. We know that there are teachers out there who have their own kids, and whether they are being told to come into work, their kids may not be able to go back into school. So that may be something that's there for them. There's also what is called emergency paid sick leave. Again, this is very COVID specific leave. That is something new, came out of the Families First Coronavirus Response Act from last spring. Congress passed last spring. And that provides leave for an individual who either has contracted COVID, may have contracted COVID, is on quarantine because they may have contracted COVID, has a family member who has contracted or may have contracted COVID. Again, this is one where there are a lot of moving parts to it that affect both who and when it applies, and also what the compensation for it is. So again, I would recommend anyone who has any real questions about that to go to the ATPE website, because it's very specifically laid out there for that. But there are a lot of leave options for individuals who are not able to go to work, either because, again, they are ill or they are in need of quarantine because they've had close contact with someone who is ill. In addition to leave options, there is, one thing that is very common that we've been dealing with a lot is individuals who are at risk because they have a health condition that puts them at risk because of a risk of infection, or that if they were to contract COVID, it would be a much more serious thing for them. And there's questions about, can the district, do I have to go in? I've got diabetes, or I've got lupus, or I'm over 65, or I have small children at home. Wide range of issues can come up. It is understood, and again, unprecedented situation, so we don't have a case law on this, but it's understood that if you are at risk, if you have a medical condition that puts you more at risk, that could be considered a disability under the Americans with Disabilities Act. And under the Americans with Disabilities Act, that could require the school district to consider an accommodation for you for that, which could be anything from remote working. It's not like that's the only possible accommodation. The Americans with Disabilities Act is, again, a very complex law, and it is very much based on individual determinations, what individual cases. So, but there are options there for anyone that has those kinds of concerns, particular ones that have some type of health condition that puts them more at risk.
Okay. So what happens, getting a couple of people saying they've lost sound, I would say the YouTube link might be an option. Are you on our YouTube channel if you've lost sound? But not that you would have heard this. What about those who are simply nervous about going back? I mean, there's a lot of anxiety. It seems like there's options for people that have either medically, a medical condition. There's options for people that have that get sick. But what if you're just, obviously we're all a lot of anxiety around this.
And this is one of those situations where, as a lawyer, sometimes I have to give bad news. We certainly hope that school districts will work to make the environment as safe as possible for everyone. I know all the stakeholders, ATPE, every teachers and educators association, every group, and honestly, every school district, there's no one that wants an unsafe environment in this situation. And everyone is, however well it's going, I think everyone is trying to do their best to make the environment as safe as possible. There is no legal right to not go to work simply because you're concerned or because there is a danger there. And again, that doesn't mean that the danger is not real. We understand that it is actually a real danger. But there isn't at this point any particular law or order from the governor or anything like that that provides any kind of protection for an educator who simply does not want to go in because, again, because of very legitimate concerns. Now, I'll probably say this in a few times, because this is one of the things we are dealing with is the evolution of this. We're talking about today what the circumstances are today. That can change dramatically based on something that Governor Abbott may do, TEA may do, and of course we have a lot of individual school districts that are still working on their individual plans. So it's important for teachers and everyone to realize that as legitimate as it is to be concerned today, and it is absolutely legitimate to be concerned today, we are dealing with a situation that as of right now, there are more unknowns than there are knowns because we simply have not seen the plans that the individual school districts are coming out with. And that is where the details are going to be, because there has not been a lot of detail requirements coming out of Austin, either the governor's office or TEA.
So I guess one question, certainly, I guess if you have a spouse who, say you yourself are not in an at-risk category, but your spouse is, or your elderly mother or your child, is one of those leave types a possibility for you?
The leave types are a possibility. It depends on the specifics again. So it is important for anyone who has an individual situation like that to look to, if you can, actually get good legal guidance. If not, look at the resources that are available. And there are a lot of resources out there. ATPE has it. But the internet is full of information regarding these resources that are available. The Americans with Disabilities Act does not apply to, I have a spouse or someone who themselves is at risk. So I don't feel comfortable going in because if I were to get sick, they might be more at risk. The ADA does not apply to that situation. It has to be your own individual health concern, not someone else's for the ADA itself to apply. But again, there are other things that might apply and might give you something that you can use if you're dealing with that situation.
And what if, an educator is like, okay, one of these sounds like it might work for me. What next step do they take?
Well, and that kind of depends on the situation. Of course, it depends on the circumstances. Again, as a lawyer, I'd say if you have access to having someone that you can talk to, get legal advice, you certainly want to do that. If not, then reach out to the school district, find out what you can from internet resources. Again, we're dealing with a situation at this point where we've seen districts, and this is something we've seen quite a few districts do, send out questionnaires or surveys asking their staff, do you have a health condition? And one of the things we've heard about from that is, do I have to share this information with them? It's important for educators to realize that one of the reasons that they're doing this is because the school district needs this information to know, who do we need to be considering accommodations for? Who is at risk? Who do we, what kind of decisions do we need to do? So we're seeing districts actually do some of the right things. Not every district, of course, because it's not required, but a lot of districts are doing those kinds of things. If your individual district is not, you can certainly reach out to them and basically say, here are the concerns I have. I have here's a health condition that I have. I am at risk. I have a doctor's note saying so. I want to talk to you about accommodations. But again, there is not a here is the thing you do regardless of what your situation is, because it does depend a lot on what this individual situation is.
Okay, well, it seems like another question that we've gotten quite several. I mean, we have hundreds of questions, but one that I'm seeing come up quite a bit is, in the next couple of weeks, many educators are being asked to report to in-service. And what do they do if they show up and they're not socially distanced? I mean, can they be forced to show up to in-person in-service? Shouldn't those all be online? What's kind of the answer to that?
Well, and I would certainly, personally, I would certainly say yes, they certainly should be online, but I can say there is no legal requirement at this point anyway, that group gatherings of educators are prohibited as on any statewide level. Again, this is one of those, I'm going to say again, one of those evolving situations that, again, the Attorney General's opinion saying that the local health authority orders aren't enforceable at this point, because the local health authority order may have said that gatherings are prohibited. So we don't really know for sure what the situation is in a lot of these circumstances, because again, we are learning as we go along. But as this is happening right now, there is no prohibition on gatherings in school of educators. Now, that's generally speaking. This is another situation where if you have a specific health concern, again, an accommodation to that health concern may be that even though there is going to be a general group of educators together, you can participate remotely. Again, that's just an example of a possible accommodation that a district, based on a request for that, might have to consider.
Okay. Well, kind of one more question on the leave front. A couple more, actually. One, what do we do about our own childcare? I mean, can I take my school age, if we're having a period of virtual instruction, but I'm required to report to campus to teach virtually from my classroom, can I take my school age children with me?
There's two answers to that question. The first is one of the types of leave that came from the Family First Coronavirus Response Act, the extended family medical leave, is specifically related to childcare needs. So it does provide leave options. Again, if your child is not going to school because their school is not open, childcare as well. But if you are not able to drop them off where you normally would drop them off, that is an option. We have seen, and I personally believe it's because of this leave option, we've seen some districts who have started notifying their staff that they are going to be able to bring their own school age, or actually sometimes preschool age children in to the school. And there is it appears, and again, this is a pretty new development. It appears that there is a wide range as to what the school is intending to do with these, whether it is basically you can have your children with you in the classroom, or we are going to have these kids in some particular separate room with someone there. One concern I've had with this, and this is new, I haven't seen it addressed, is with school-age children, of course, they are supposed to be receiving instruction, and they're supposed to be receiving instruction based on whatever their age and grade level is. If a school district is organizing this in a way to provide that instruction for the students, then honestly, it is probably something that a district can do, but that's a requirement. I mean, it's a legal requirement that all school-age students receive instruction, and there is no exception to that based on COVID. So again, this is something that's just recently come up. So we haven't seen what it is that districts are actually doing, but that's a big concern, is that all students, including the students of teachers, need to be receiving proper instruction.
Okay. Well, along those notes, what happens if, we show up to campus or the in-service and we don't feel safe? Do we have any rights or recourse?
Um, there's nothing good. I will say it is better to deal with it ahead of time rather than waiting until you get there. And I wish there was a better answer than that, because again, my answer again goes to the idea that you have something, a health condition that puts you at risk. So that there's something that you can say to the school district, I should not be in a group because of risk factors that I am dealing with. If that's not the situation, there is no good answer, or no risk-free, I should say, answer. Certainly understand having to take health concerns into account in going to in-services and that kind of thing, but cannot say that you might, individual teacher who leaves because of health concerns might not have to deal with repercussions for that. It may be worth dealing with the repercussions for that, but there could be. Again, there is no section in the education code or any other code that says you can leave if you don't feel comfortable.
Yeah. Well, you know what? Another area that we've heard so much about is liability. Is a teacher liable if one of their students contracts COVID?
Here I can give you a much better answer. The answer is
that's something.
Yeah, the answer is generally no. That is not something that you as an educator are going to need to really worry about. You actually have fairly strong immunity protection from liability for actions that you take. Now, I'm a lawyer, which means there always has to be a but after everything that I say, and there is a but here too. It's important for you to know what your district's requirements and policies are, and important for you to follow them to the degree that you can, because the immunity that you have is dependent on you doing something that is within your discretion. In other words, you have some choice as to whether you're going to do it. Doesn't have to be the right choice. Actually, again, immunity is strong. Teachers have done some honestly really dumb things and not been found liable for them because of this immunity. But there has to be a choice. And so if you're required to do a particular thing, it's important for you, if at all possible, to do that particular thing. So perfect example is masks. If you are required to wear a mask and you don't wear a mask, you might lose your immunity for that because you don't have the discretion to not wear a mask. The governor's order says you are supposed to, unless the governor's order doesn't apply. Again, it can get a little complicated in particular individual situations, but if it applies to you, that's not something that you have discretion over. You can lose your immunity. But generally, as long as you are making good faith efforts to follow the rules that are there, you do not have to worry about liability.
So kind of flipping that on its head, can my district force me to sign a liability waiver?
That is actually something that's very interesting. That is something that we have seen a lot of questions about liability waivers. That's come up in social media, and we had not until actually a couple of days ago actually seen a single one. And the single one we saw immediately got pulled, and a public apology got made. This is something that has kind of taken on a life of its own, I think. There isn't a good reason to have a liability waiver. There's serious questions as to whether a liability waiver would be enforceable. They are waivers that happen before an event are not something that courts like. It's important. The person has to understand what it is they're waiving, what risk they're taking. And if that's not the case, waivers generally not are even enforceable. So again, we've seen a lot of talk about waivers, but we haven't actually seen any. Certainly something that, again, you want to get legal advice if you actually were presented with one, but probably it's very unlikely. Very many people listening to this are actually going to see one themselves.
So you brought up in that answer or a couple answers ago, one of the hot button issues of summer 2020, which was masks. And certainly ATPE members have varied feelings about masks, just like all Texans have varied feelings, all Americans do. But who's required to wear one?
That is based on the two things. At this point, that is based on the order of Governor Abbott. And Governor Abbott's order has very specific requirements about masks. And to the degree they apply, they apply. Again, this is a particular order and it can change in one way or another, either by getting more restrictive or getting less restrictive if Governor Abbott decides to amend the order that he has done already. At this point, what the order says that masks are required except in particular circumstances. They are not required for anyone under 10. So there are younger students who are not going to be required under Abbott's order to wear a mask. They are not required for anyone who, because of a medical condition, cannot wear a mask. If there are breathing issues or something like that. Now, my guess is the order doesn't say so, but it's going to be expected that anyone claiming that is going to need medical documentation showing that they actually do have a medical issue. It is not required while eating or drinking. It is not required while exercising or social distancing. And the order does not apply everywhere in Texas. If a county, number one, has a limited number of cases, and that cases is not determined by the school district, it's determined by a state agency, limited number of cases, and a county official opts out of mask wearing, then in that county it is not required. So it isn't, but again, this is only in limited cases, and it is not a decision of a superintendent. It's not a decision as a principal as to, well, we're not going to wear masks here. So, but generally speaking, again, other than those cases, if you are inside and cannot socially distance, and that gets to be a little bit tricky too, masks are required. Now, the social distancing, I think, again, it's a little tricky because is it really possible to social distance? And practically speaking, I think in most class settings, school settings, that is not really possible. You may be able to put desks 6 feet apart, but the idea that everyone is actually going to be able to stay 6 feet apart is a very different matter.
So what if one of my students' parents is anti-mask? Can I require that student to wear a mask?
As long as the order applies, it does. Again, we have an order from the governor of Texas, and that is legally binding. Doesn't matter. Again, we can have our own personal opinions on whether we think it's appropriate or not, but it is required. I'm not wearing it right now because I'm in my office with my door closed, but I have my mask here because it is required that I have one, other than in circumstances where I am right now. Does not matter what my personal political or health opinion of it is.
Can my district force me to be tested for COVID?
That's a very good question. The answer is it depends on whether your district has an objective reason to do so. They can't basically just say, look, there's no reason in the world we would think you would have it, but we're going to make you take a test anyway. But as long as they have an objective reason for believing you could have it, they can require you to get a test. Objective reason could be that you have been in close contact with someone who has had it. Objective reason could be that you have been somewhere where it was, where it was prevalent. But there has to be something. Again, this is, I'm going to use that unprecedented word again, but there's no better word for it. We don't know exactly where the line is. How objective does it have to be? But that is basically the standard. If they have a reason to believe you may actually test positive, they can require you to have a test, even if you're asymptomatic.
So on that note, it doesn't seem like, isn't that an invasion of our privacy if we have to report that we've been exposed to COVID or that we have COVID? Can we keep that a secret from our district?
No, and the answer to the question is no, you cannot. And I certainly understand the idea of it being an invasion of privacy, but there are certain exceptions to the right to privacy, and this is one of those. We have to share our social security numbers with our employer. There's a lot of information we have to share with our employers. And this is simply one that the law requires, and the law does require us to share this. The TEA guidance requires it of district staff, that if they test positive or believe that they may have contracted COVID, they are required to tell the school district. Again, a situation where at some point in the future, some entity, whether it is a judge in a court or Governor Abbott or somebody else, may supersede that, or TA may change its own guidance. But at this point, educators are required to tell the school district if they have tested positive or if they believe they may have been exposed.
So one thing it seems like, I mean, all of the TEA guidance, the recommendations in there, they're just that, they're recommendations. That'd be a good idea if you did this, or you should consider having hand sanitizer. What if I feel like the district's precautions are not strong enough? Can I make them stronger within my own classroom? Can I take my students' temperatures at the door? That kind of thing?
The answer to that is probably no. It's going to, I say probably because it's going to depend, again, a lot of this is going to come down to what the individual guidance or individual rules at the individual district are. And a district might very well say that, yes, individual teacher who wants to take temperatures can do so. There's nothing that prohibits a district from saying that. But there is also no right to do it if the district doesn't allow it. So it comes down to what that local, whatever the district's rules and guidelines are. And that's why it's going to be very important for a teacher to know and understand whatever their individual district does come up with. Because again, there's very little that has come from Austin that says district must do X, Y, and Z. There's some, but there is not very much. It is going to be almost entirely up to the local school district to determine what it is that individual, what are our safety precautions going to be, and what is the authority of the individual, whether it's a teacher or administrator or whoever, as far as enforcing those or coming up with something that they feel like is more appropriate.
When it comes to precautions, can I be forced to provide my own hand sanitizer, my own masks? I mean, is there going to be district resources for that kind of thing? And they can't keep up with the soap in the bathroom. I mean, a lot of people are saying that.
And it's going to depend. I mean, honestly, we've seen, the efforts that TEA has made to purchase supplies and provide them to districts. We know districts are trying to do that as well. One thing teachers know, though, better than I, but I know from having worked with teachers for over 20 years now, you get a lot of your own supplies. I mean, whether it is pencils and pens and crayons and stuff like that, school year, or something like what we're dealing with now, saying that, oh no, a district is going to provide all of the needs. I wish that were the case, should be the case, but I cannot say that that is going to be the case. A lot of districts are doing everything that they possibly can. But there is nothing that says districts must provide, these kinds of PPE or sanitizer or to the extent that an educator feels is appropriate, even if it is appropriate.
Yeah, that's a societal, it's an extreme case of a societal problem where teachers have to pay for so many of their own supplies.
True, absolutely.
So shifting gears a little bit, I think a lot of teachers have seen their work days extended, and I think a lot of districts are extending the minutes in the school day to try to get more minutes in case they have to shut down for some period of time later. Can an educator be expected to be compensated for that extra time?
That is going to depend a lot on the specifics of, most importantly, the educator's contract, and a fair number of other issues, but the contract is by far the most important thing here. Most teachers' contracts state in it that the district gets to set the hours, the schedule, and that those can change. Now, there is some limit as to how much the change can be. Basically, what it comes down to is the change something that the educator recognized, or at least should have recognized as being within the realm of possibilities? You know, educators work extra hours all the time. I mean, again, no teacher works their regular work hours. I mean, they're grading, they're prepping for the next day, they're dealing with parent-teacher conferences. I mean, that is part of teachers. All teachers have always known that, okay, the school day doesn't necessarily end when the school day ends. That is a part of this. So it depends, and I wish I could say there was a black and white line there. There is not a black and white line there, no. It really depends on what the reasonable expectations of the teacher were. So there is some limit as to what extra a school district could do. We saw back last spring at one point, I can't remember whether it was individual campus administrator at this point or school district, but put out that they were expecting all of their staff to be available from 8 in the morning until 8 o'clock in the evening, that they were supposed to be available at their computers at all that time. That did not last long. Actually, that got rescinded very quickly. That clearly is not, basically being expected to be available 12 hours a day, 5 days a week is not a reasonable expectation. But how much is too much? Like I said, I wish I could tell you that there was a line, 30 minutes a day is okay, but 35 is not, but there is not a line there. Well, again, something that if you are in that situation, and have access to someone to talk to get legal advice on, it's a good thing to do that, because again, a lot of this comes down to the contract that you have.
So another thing that I think we've been hearing a lot of from our members and on social media is duty-free lunch. If the kids have to eat lunch in the classroom, does that mean the state has decided that duty-free lunch isn't a thing anymore? What's going on with that situation?
Well, and this is going to be something that I'm curious to see how this plays out, because just from the little bit that I've seen as far as district plans, it does seem that one thing that looms large is the idea, just so that, again, we don't have too many students in one place, that the students will eat lunch in the classroom. And that, of course, raised the question of, okay, who's going to be with those students? Now, as pretty much any teacher knows, there is a provision in the Texas Education Code that provides for duty-free lunch, 30 minutes of duty-free lunch, 5 days a week. That provision has an exception in it that allows a district to take away that duty-free lunch in certain circumstances. And I will say that the COVID situation does apply to one of those circumstances. But the law only allows the district to do that one time per week. In other words, the district cannot say that, okay, you are going to be eating with your students or watching your students, or not get your duty-free lunch. You can watch them eat, but not get your own duty-free lunch any more than one time per week. Now, I do have to add a caveat here too. Again, this is provision Texas Education Code. It is possible that an individual district could have opted out of this provision as a part of its district of innovation plan. I have honestly not seen myself any district that has opted out of duty-free lunch because of that. And simply by being a district of innovation does not mean that duty-free lunch does not apply to you. District would have had to have opted out of that specifically. There are a lot of other provisions that districts have opted out of much more commonly. Again, I have not seen that. But so there is an exception to it, but it is a very, very limited exception, only one time per week. Other than that, the district is supposed to find someone else so that teachers can get their duty-free lunch. And duty-free lunch, I should clarify, applies to classroom teachers and full-time librarians.
Okay, that's good to know. Along the lines of, things related to the Texas Education Code, I think one thing that's been on everyone's minds is if an educator is required to quarantine, can the district make them take their state leave days? And will they be compensated if they don't have enough time to cover the need to stay home? I mean, the CDC recommends self-quarantining for 14 days after a possible COVID exposure.
The answer to that is the district can require an employee to use leave and use their own leave. Now, again, as we talked about a little bit earlier, there are some specific COVID-related leave options that are separate and apart from personal leave or local sick leave, if that is available to them. And one of the provisions applicable here for the emergency paid sick leave that I mentioned before is it specifically says that, number one, it applies for being quarantined, like I said before. It also says that a district cannot require an employee to use their other leave first. In other words, if an employee does have to quarantine because of school district decision that they need to, the employee can say, okay, I want to use my emergency paid sick leave. Probably a good idea because as it stands now, these two provisions, emergency paid sick leave and the extended family medical leave, expire on December 31st. Now they may be extended by Congress, but based on the law that was passed last spring, they expire on December 31st. I don't think anybody back last spring was expecting we were going to be dealing with the situation at the level we're dealing with it now. So again, it is very possible that this may be extended, but it will have to be extended for those leave options to still exist after December 31st. So it may be, if you're in a situation like that, you do want to use that because you may lose it later. Now, it is also possible, and I know that some districts are considering this, that a district will, if they've decided that they feel like it is appropriate to place a staff member in quarantine, send them home, that they'll place the person on administrative leave and not require them to use any of their paid leave. That is possible. Again, there's no legal requirement in the district to do that, though. It's going to be entirely up to individual district decision as to whether or not they're going to go that route or not. It is something a district can legally do, but they're not legally required to do.
Interesting. Now, something that a lot of educators are wondering about, can they be required to teach both online and in person? Can they be required to videotape themselves and then post that online? I mean, how does all that work?
The general answer to the question is yes. You likely are going to be able to be required to teach in person, remote, some combination of the two, depending on just how the district, again, how the district decides that its instruction is going to be provided. That's the general answer. Again, there can be specific exceptions to that. Probably the clearest one would be the teacher, again, who has health concerns that relate to teaching in person, that they may have an accommodation request that they need, that needs to be considered for that is a good example of a specific exception to that general rule that yes, the district could require a teacher to do one or both, could require that teacher have students in their class with a camera so that the students who are doing it remotely are actually seeing the same thing that the students in the class are seeing at the same time. Again, there can be a myriad ways that schools end up doing their remote and in-person instruction. We haven't seen enough districts that have said how they're going to do it to see whether there is, going to be a rainbow of ways of doing it, or whether most are going to do it one particular way.
I think another thing on a lot of our members' minds, particularly our associate members' minds, is the potential for a sub shortage. I think that's going to be a very real challenge that school districts face. Can a district employee be required to fill in for a substitute if there's a shortage?
The general answer is yes. That, again, it's not supposed to interfere with your duty-free lunch, not supposed to interfere with your planning time for teachers and librarians. But the general answer is yes. If you are especially an associate, don't have a contract, you, like myself, can be asked to basically do anything that the district feels is appropriate for you to do, as long as that thing is not itself illegal. And it could be subbing, or it could be watching a class that has a teacher on a video screen, because that's the way they're doing the instruction, but they need an adult in the room. So it is very possible that could happen on a general level. Again, this is another example of there may be an individual person who has, again, because of health concerns or something like that, has a reason that they may need to or want to request an accommodation to say, understand that generally speaking, that's something could be required to do, but because of these concerns, health concerns I have, I don't believe I should need to do that.
Yeah, so there's so many complexities with all this. It's really just, it is truly absolutely unprecedented, which is the most overused word of 2020, but for sure. Kind of just quickly, we have about 4 minutes left. Certainly we have enough questions for another webinar, which is something we will work on scheduling. But let's turn our attention briefly to what happens when someone does get sick, because that is going to happen. That is just a given. Mm-hmm. TEA has stated that employees, students, and parents will be notified when a student or a staff member tests positive for COVID-19. What's this notification going to look like, and who at the school is responsible for sending it?
Honestly, we don't know exactly what that notification is going to look like. What TEA has said and needed to say is that the notification has to go out, but the notification has to be consistent with privacy requirements, because there are separate privacy rights in this. So we don't know.
Does HIPAA apply here, or
what's that?
Is this a situation where HIPAA applies, or
this is a situation where HIPAA would apply? Okay. Yes. So the notification, we don't know exactly how districts will be doing this, because again, the guidance that we've gotten so far has been very general, basically on the level of need to give notice, but the notice has to be in compliance with all the privacy laws that are out there. I think it is most likely, but again, this is most likely, that what will happen is individual educators who have been in contact with someone who has either tested positive or it's believed could have contracted COVID will be notified that they have been in contact with someone who has tested positive or has or may have contracted COVID. I think it is unlikely that individuals will be named. I think it will be something general like that. But again, that is just speculation on my part based on understanding of what the privacy rules are, which basically come down to the fact that you're supposed to protect the identity of the individual and the individual health information of that individual. Knowing that, it seems most likely that it's going to be something general, that you won't, you may be able to figure out who, of course, for practical reasons, but you're not going to be told who. But again, that is just my best guess based on this. And as far as who is going to be responsible for putting this out, again, that's going to be a local decision as to whatever the procedure each individual school district comes up with.
We're coming up right on time. So the one last question that I have for today is, and this isn't necessarily a legal question, but what would you tell Texas educators to help them try to stay sane during this time?
The most important thing is probably something I kind of alluded to before, which is understand that we are in the process of figuring this out, and everyone is in the process of figuring this out. So the fact that we don't have all the answers yet, and you don't have all the answers yet, doesn't mean that the answers aren't going to be coming. And you are completely reasonable in feeling concerned and feeling like you don't have the assurance of being safe at this point. Again, that is a completely reasonable feeling at this point. But that's because there's a lot that we do not know at this point. This situation is going to continue to evolve. It has changed fast over the last few weeks, and it is going to continue changing fast. Back a few weeks ago, no one had to wear a mask. Now almost everyone has to wear a mask. Back a few weeks ago, we thought that districts weren't going to be opening. Now they're going to maybe be opening, but maybe remotely, but not necessarily 100% remotely. We're not sure, and we don't know what the reaction to that is going to be. So like Kate said, we knew we were going to have more questions we were going to be able to answer in an hour, number one. Number two, we know this is changing fast. And what we talked about today, even if we covered everything, doesn't mean we will have covered everything that's not going to be important in a week or two. So we are going to consider, doing this again. And if things have evolved to the point where providing the information to you all is worth your time to listen, we'll be here to provide that for you. So hopefully this has been useful to you. I wish I was able to give you more black and white answers than I'm able to today. Hopefully you have left this with more information than you have come in with. And it has been worth your time. I know it has been worth mine. Anything that I can do to help you all deal with this situation is certainly worth my time. I have always felt very lucky to be able to work with public educators. And just one more exception to that. So I will sign off just by saying thank you for all that you do.
Absolutely. Thank you so much. Thank you, Paul, for all that you do. And also certainly thank you to everyone who's joined us today, both here on Zoom and then also those of you on the overflow on YouTube. We will reach out to you regarding the archive of this and also certainly let you know if and when we schedule a follow-up. So I wish you all of the best for the upcoming year. Know that we think about you. You are our reason for being. So take care and have a good evening. Thank you.
Thank you all.